Yeah, so on the agenda today, I will introduce quickly myself and then the impact assessment as a topic and how it seems to be popping in different regulatory contexts, not only AI currently, and my research questions. And it divides into two themes. First, whether impact assessments is a legal design pattern which is present in different contexts and where we can learn from its strengths or failures in different contexts when we regulate AI. And then my second research question deal with the question of what impact assessments cannot do. Because what I observe sometimes in European discussions surrounding AI, that it seems like this golden ticket, that we have all these risks, but when we have an impact assessment, they just miraculously go away, and it's a tool to solve everything. And I will reflect on different sides of the shortcomings, looking on the more economic one, or more socio-legal ones, towards the end of the presentation. And then I'm happy to discuss next steps, both in research, but also to learn about Israeli policy making in this area. A few words about myself. So my background is in IP law, so for quite a while I dedicated time on studying open innovation and patents and compulsory licenses. And then in my postdoc research I started going more towards law, technology and society. So I'm at the Legal Tech Lab of Helsinki, leading a research project funded by the Conner Foundation on the long-term human rights risks of smart city technologies. No affiliation with long-termism. And now towards the end of the project, I start seeing some connection point between my earlier research in IP and then more law and technology research. And this presentation represents this indirect mergers of these two viewpoints. Now to impact assessments. It's not a tool which was invented with AI discussion. It has been already present in environmental protection context, but generally it can be characterized as a study of some harmful effects associated with the action which is planned and where there is an interest to potentially mitigate them. And another definition really stresses that it's a structured process to assess those potential risks, and that it can be taken both on the kind of more wider policy level, so we know about legislative impact assessment and technology impact assessment, where you might be looking, for example, of a specific field, but it can be also applying to a specific project, which often AI impact assessments are dealing with. And in European Union, impact assessments are already present in technology regulation, so it represents this more common approach, which is risk-based, fundamental rights-driven regulation of technology, with a lot of emphasis on the ex-ante control, so what can be done with solutions in advance rather than later. So you may be already familiar with the General Data Protection Regulation, which requires data protection impact assessments in the presence of high risk for rights and freedoms. And this can be interpreted to kind of cover the whole palette of fundamental rights. And the conditions for using this impact assessment are often, they go together, for example, with mass surveillance or mass algorithmic decision-making processes. So it has a connection point with AI. The second more recent regulation is Digital Services Act, which regulates online platforms. And here the assessment concerns very large online platforms, and they need to assess systemic risks. And as a part of these systemic risks, they will need to look into negative effects on a limited palette of fundamental rights. So private family life, freedom of expression, prohibition of discrimination, rights of a child. However, one can read more to it if you kind of interpret all the criteria in the whole act. So there's this presence of more fundamental rights focused impact assessments in European law. And how does it look for artificial intelligence? It's acknowledged that it can have detrimental effects on fundamental rights during its life cycle. It's kind of common policy understanding in Europe and elsewhere. But where is Artificial Intelligence Act heading with this respect? Well, in the kind of earlier policy documents, there was a keen interest in fundamental rights and AI ethics-based impact assessments. So in a high-level expert group on trustworthy AI, this was mentioned. But then if you look at the first draft of AI Act, there wasn't really explicit mention of it. The fundamental rights were here and there, then also the division of high-risk users, banned users, and non-high-risk users, they were justified also through the lens of fundamental rights protection. But it was kind of ambiguous whether there was an obligation to really look into fundamental rights risk in a very systematic manner. There's a lot of literature like arguing back and forth. However, one should be noting that the most recent Parliament's proposal did include explicit fundamental rights impact assessment into it. And also on a wider scale in European development. So for example, Council of Europe is moving ahead with proposal for draft convention on AI, human rights, democracy, and rule of law. And here, fundamental rights impact assessment is also introduced as a tool. I mean, probably will take a while how this instrument will come into first final form and whether it will be ratified, but it does signal kind of general interest in adopting this tool. And then finally, in European context, there is also ongoing process of introducing corporate due diligence directive. And here one could interpret that human rights impact assessment could in some cases also concern AI applications. So this is kind of the landscape in Europe currently. But then if we think of AI impact assessment, there's a lot of impact assessment that could come into play. So first, just as a kind of note that we have this established impact assessment that's been around for decades. So we have legislative impact assessment, which are done almost every time a law is passed, environmental impact assessment, where this thinking was coming from, and kind of spreading into other areas, then the technological scoping impact assessment. But in connection with AI, we have wider discussion on algorithmic impact assessment, so part of the algorithmic accountability discussion. We have discussion of human rights impact assessment, which is gradually starting to connect with AI discussion. I mean, there's a history of privacy impact assessment, which can play a role in connection to AI, and also ethical and social impact assessments, which kind of grew out of environmental impact assessment, could have a connection point. And as a curious thing which I observed in intellectual property law was that impact assessment seems to be a thing that people intuitively propose when we're dealing with uncertainty and technology. So I was reading this, I think it was a book chapter by Justine Pilat about ordre public exception for patents on emerging technologies, and should patent law somehow govern it better? And she was essentially also proposing an impact assessment for patents on emerging technologies. So this is something we tend to lean towards intuitively as a legal tool. Now, what I'm wondering here is that, are we witnessing a regulatory trend, or is there something more to it? And if it's a trend, and if we're so attracted to the idea, are we potentially over-relying on impact assessments as means to mitigate technology-related harms on fundamental rights or a broader palette of normative values? And my research approach is first, I will characterize impact assessment as legal design patterns. Legal design patterns is an idea proposed by the director of Legal Tech Lab and a colleague from the Alexander von Humboldt Institute for Ancient Society. I will break it down quickly to you next. And then my second approach, which is at the core of this presentation, is my attempt, it's ongoing process, to do a systematic review of the shortcomings of impact assessment, and this approach draws from research on the limits of open innovation in IP, where Eva was working already in 2006, and where also my PhD was kind of elaborating, and now I take that mental framework into algorithmic accountability discussion. Now, are impact assessment a legal design pattern? So on design patterns, I don't know if you're familiar with this approach, but it originates from architecture, and it was proposed by Christoph Alexander in the 70s, where he was making a claim that in architecture there are these recurring solutions which are quite universally perceived as functioning in terms of how city is livable and how different inhabitants of a city perceive it as functioning. And rather than going into the theory, I just want to give a couple of examples that he was proposing. For example, he has a book where he breaks down these different patterns, that people enjoy quiet parks where they can go and contemplate away from the bustling cities, and then also that they have a need for accessible gardens where children can play. And on Saturday we were on an excursion with Annie to learn about White City, and I learned about the architectural project or kind of approach of Tel Aviv by Geddes. And he actually designed then Tel Aviv in a way where you have these pockets of greenery and quiet in the blocks. And actually then I found a source that he may have indirectly influenced Alexander's thinking by developing these patterns. At least there was one source on that. So this is just to kind of get an idea. But now back to law. So this design pattern approach, it was first adopted to computer science to identify what solutions work in different architecture, what not. They even developed a concept of anti-pattern, what doesn't definitely work. And now there's an experimentation of using it in the context of law. Now, what's important to understand, I think maybe some of you are familiar with the discussion regarding legal design, and this is different. Legal design is, for example, what is your interface with a contract? If it's understandable, could you use some visual cues to make its content accessible? But legal design patterns looks more into architecture of law and whether we use repeated patterns to solve similar problems across the jurisdiction. So going to Alexander, he qualifies design patterns as acts and processes, that there is something fundamentally invariant and which is core to their access. And even if you repeat it 1,000 times, there's still something of an essence there. Now, again, some cues why impact assessment might be a pattern. So in AI Society of OECD report, there was a characterization of risk mitigation, kind of core features. You have objectives, risk assessment, risk mitigation. We have this impact assessment present in different contexts. And finally, one could maybe characterize impact assessment as a process of forecasting and mitigating undesirable outcomes set in the future before engaging with said activity. Now, in my ongoing work, I look into different literature on impact assessment and what could be kind of essential elements of impact assessment as a pattern. And there are some themes that emerge from it. So there's always a normative basis, there's always a trigger point. When do you start evaluating, do you need to do an impact assessment or not? Stakeholder involvement, transparency, process recurrence. I will not go into details, but just to kind of make a point that we're looking at something which is recurring, and we might learn from it for the purpose of AI impact assessment. Now, what impact assessment cannot do? It seems a bit negative research question. I mean, we have quite a lot of hopes for them solving our issues with fundamental rights and reasonable long-term risk associated with AI. So where this approach stems to is actually Niva's work on open innovation and Creative Commons. And in this paper, she broke down what are the boundaries of Creative Commons and open licensing of copyright in terms of solving the whole issues of overprotection of copyright in IP. And then in my PhD I was doing similar things with patents, but this approach I find it very helpful in terms of being sober about what positive things which we are drawn to, like what they can do and what they cannot do, and learning from the boundaries helps us to understand what other alternative regulatory measures we can take. So I looked through AI impact assessment literature, also social impact assessment literature, and a little bit of risk impact assessment literature through the lens of what do they mention as where does this instrument fail, and I tried to group them according to the type. So you have technical, normative, economic, more societal or socio-legal, more related to organizational structure and social, and then this bucket of cognitive, behavioral, epistemic issues. So in terms of technical shortcomings, these are more specific to AI, and so we have, of course, the black box problems and the limits of explainability, which we kind of run into whenever we discuss AI. There's some cultural thing in terms of acquiring the meticulous documentation of the, well, these authors talk about audit process, but they were talking a lot also about impact assessment, and whereas the culture of AI development might be very agile. Then problems of document traceability through the process, blurred categories of AI discrimination, where does it come from, like what should you be looking for, then the entanglements between data and AI system and how can you trace the impact or predict impact with respect to that constellation, and then also problems of predicting adversary attacks and unintended uses. I would wish to expand on this list while visiting Tel Aviv University, so I'm really looking forward to your feedback on what else could go wrong specifically with respect to AI. But then there are also shortcomings which are quite common to most impact assessments, but with some nuances for AI. So first is incomprehensiveness of normative frameworks. So you might encounter issues which are legal, but they don't feel right in the AI context. You might have instruments that have too narrow of a focus. So for example, it's Digital Services Act's impact assessment and the 4 fundamental rights mentioned isn't enough, as an example. And then there's some like more doctrinal bigger issues that what are the limits of corporate human rights obligations? Can you actually even make this strong obligation for companies to look at all fundamental rights, for example? And then a big issue which both social impact assessment researchers and AI researchers are talking about is how to communicate and translate values to their application context. Super difficult. There are some proposals coming. I see literature coming to this direction. Then how to solve conflict of norms, especially if it's practitioners who need to balance them when they try to make an impact assessment or mitigate the harms. There might be also like conflict between participants' values. And then go into more detail what qualifies as impact or level of accepted risks, and you do it in a company with an abstract framework, how does it work? Then also there has been recently so much literature on AI ethics frameworks that you might just be overwhelmed with what framework to follow. And then, of course, these are vague concepts. They're meant to be vague, but how to operationalize that. And then, I mean, also methodology can be challenging. This is a whole kind of bigger cluster of issues. Then we have economic shortcomings. So, I mean, we're dealing with an obligation of private sector and there's always a key issue of lack of incentives. So, I mean, making an impact assessment, it can cause reputational damage. They might be tempted to undervalue risk in self-assessments. Then there's also a virtue washing element, so they might feel like they're kind of doing good PR with impact assessment, but it doesn't necessarily translate to what they're doing, or they do the bare minimum. Then if you have third-party assessors, there's this problem of intransparency between organization and the technology, and just inherently you have the need to be closely connected to the developers to understand what's going on, and this is something which needs to be constantly overcome in these processes. Then transaction costs of just interacting with the organization, translating what these rights mean in the given context, mitigating risk, just a whole bunch of issues. Under-enforcement, more of a legal matter, but it also comes from the intransparency of what's going on in companies. Similarly, lack of oversight, and then also this impact assessment, they don't scale very well if you do them well, so it can be quite frustrating then for an agency using them to kind of be very conscientious with what they're doing. Behavioral cognitive epistemic issues, also something where I would be happy to get more feedback, but in essence it's about assessors' ignorance. I mean, there are cognitive biases such as hyperbolic discounting of the future. It's also difficult to trace what developers' assumptions are. They might be tacit, they might be unaware what kind of biases they might have in them. There's also just limits of comprehension, both in terms of technical knowledge and maybe risks at hand. And then on a more wider scale, the problem of unknowns. So, I mean, one concept is of black swans, so something unpredictable has a huge systemic impact on everything, or discussion of polycrisis, that if there's a several cluster crises in the society that are interconnected, then just everything becomes a little bit obsolete. Yeah, and then if you use counterfactual, there's still limits to what you can do, and limits to how far in the future you can somehow assess what you can do. And finally, social, interorganizational, you have issues with lack of expertise, lack of integrity, lack of proper process implemented in the company, lack of feedback, lack of representation. The process might be risky to the relevant stakeholders who are involved with it. They might fear that they will have repercussions, and this way you might also miss the on the ground harms, especially if they take in another place, in another context, in another time. So yeah, that's quite a bunch. Oh yeah, sorry. Well, there's issues with reinforcing those in power. If it's more of a kind of virtue washing thing, issues with not having redress mechanisms, and missing the cumulativeness of effects. But generally, this category relates to kind of common discussions of the limits of self-regulation if there's no oversight involved. So yeah, that was all the negative, but what would be the best way forward? So what I do like about the design pattern approach is that it also invites us to think what other alternative solutions there could be. So, and also it allows us to learn from other types of impact assessments. And I think now it will be important to learn from them, identify what's special about AI-related impact assessments, and let that inform regulatory choices, refine the impact assessment methodology, knowing these clusters, but also be very sober of where do we maybe come to the conclusion that impact assessment don't work or they need something complementary. And what I see often in the literature as a kind of common solutions to issues is that, oh, like self-regulation is not really enough, and doing it only once is also not enough, so having a repetitive loop. And it's quite intuitive on the outset. But I think one can get more nuanced about this in the future. And in research, so I'm working on the impact assessment as a legal design paper. I'm working towards what impact assessments cannot do paper, but I'm happy to discuss potential for further research, broader collaboration, for example, with other impact assessment specialists beyond law. This kind of process of co-developing impact assessment for AI, doctrinal comparative approaches, learning from Israeli point of view, which is more self-regulation oriented, and then cognitive biases. I would love to learn more of that. So thank you, and looking forward to hearing Corey's comments.